All right, I'm going to go ahead and get started. Have you ever used these documents before? It's the buyer possession and the seller's possession.
Yeah, I have before.
Okay. Well, hopefully some other people will jump in and join us. I'm going to go ahead and start with the buyer possession agreement. As we all know, these can be cause for concern and treaded upon very, very carefully. Um, and we always recommend to reach out if you're not comfortable with how to use these, because this information is important. And I would say 90% of the time, we want to have these done and signed with ratification, because trying to negotiate this once you're under contract can be extremely difficult. So starting off with the buyer possession agreement, obviously it's going to be that date, and later on in the first paragraph, you'll see here where you use the date from the purchase agreement. So starting up at the top, it's the date that this is actually going to be signed, with buyers and sellers filled in. Let me just make this go away. Okay. Buyer and seller have entered into a purchase agreement dated as such to purchase the property, again, as such. The important thing here is this possession agreement is intended to be used only when buyer wishes to take physical possession of the property for a short term prior to the settlement date and does not address the risks. And this is where we, coming down to the bottom of number 2, buyer and seller should each seek legal counsel prior to executing this possession agreement. It actually says that in a couple of different places here, but that absolutely must be stressed. And we'll get into why as we work through here. I have used this a few times. Like I said, it can be a little bit tricky, but there was one time in particular that I used this. It was intended to be short term, and it ended up actually being much longer than that. This was a couple years ago. The reason why, and I'm telling you this because there are certain situations where it does make sense. It was a home that was in the seller's family for a long time. The sellers actually were deceased, and it was their 2 kids that were selling. And when we got under contract, the listing agent didn't tell us that we were actually waiting for the city of Portsmouth to split the parcels. And my clients wanted to hang in there as long as they possibly could. There was a separate parcel they didn't even think that they were getting, but tax-wise was all in one, and they had the sellers had already agreed to sell that parcel to somebody else. So what was supposed to not take very long, but we were all kind of at the hands of the Portsmouth government, who basically was it took a lot longer than we thought, but everything did work out okay. So again, just be really careful when using this and the intention for. So coming down to 3, possession property acceptance. Buyers decides to take physical possession of the property prior to the settlement date. Seller permits buyer to occupy the property. So my situation was a little bit different because we actually went way beyond the original settlement date. We just continued to extend. So they were actually in place quite a bit longer than was intended by anybody, but like I said, it works out. Buyer agrees that unless noted to the contrary, buyer's possession of the property under this possession agreement constitute the fulfillment of inspection and walkthrough as described in the purchase agreement. So that's really important. You're essentially taking possession as in lieu of a walkthrough. You can still do one, but you're accepting the property as is. Not insurmountable, because their buyer's going to take possession and potentially start, doing things to the property. I always advise, do not make a hole in the wall. Do not make any changes to the property while you're in there until we actually get to settlement. So deposits rent, buyer shall pay a security deposit in the amount of, depending on your timeline, I recommend either between $500 or $1,000 for the security deposit to be held by, and here where it says deposit holder, escrow agency. With buyer's execution of this possession agreement, for the privilege of possession, buyer agrees to pay seller X amount. Now, in every situation I've used this, we have crossed out per month and put per week, if the expectation was it was going to be longer than 7 days. If you're talking about just a couple of days, cross it out right over here per day. But we did a weekly rent. And And when you're writing this on the buy side, obviously we're looking out for our clients and not trying to make them spend too much, but a reasonable expectation can be set here. And that needs to be discussed with the buyer and the listing agent. If possession occurs after the first day of the month, the first month's rent is due in the amount of, I think what I've done in the past is actually cross this off, but if we're looking at a month situation, that's where you would fill that in, shall be paid on a pro rata basis at time of possession. So essentially, the buyer is writing 2 checks upon moving in, the deposit amount from the first line, and then the amount for the rent. Rent for any subsequent calendar month, meaning if it goes beyond that month, shall be paid in full on the first day of each month. This is essentially a landlord-tenant agreement and needs to be treated as such. And as a result of that, we need to be very careful in our roles. Again, I'll get some more of that later. At settlement, security deposit and rent are paid in advance beyond the date of settlement. So shall be refunded to buyer on a pro rata basis for the final monthly period. In the event rent is not received within 5 days after the due date, a late fee amount shall be due. And I have a tendency to put in a pretty higher amount here. We don't want to see anybody not paying the rent. If the settlement does not occur under the purchase agreement in accordance with its terms, buyer shall vacate the property within. Hopefully we can put something in here that's agreeable to everybody. 1 day, 5 days, and 10 days is how I've seen it written. After any written notice from the seller or listing firm. Any default under the possession agreement shall constitute a default under the purchase agreement, and any default under the purchase agreement shall constitute a default under the possession agreement. We don't want to get caught up in the back and forth between. This is where we remind them that they have had a conversation with the attorney before anybody signing this, coming back up to section 2. We always want to reference that, and we kind of need to keep our hands clean out of this. Obviously, nobody hopes for any kind of a termination or move out. If you think there's any possibility that that's something that would happen, you really want to recommend against this kind of agreement to begin with. Buyer's responsibility, buyer and seller each warrant covenant to the other that they will each undertake in good faith the actions necessary to complete the sale and settlement of the property in accordance with the terms of the purchase agreement. During the period of occupancy of the property by buyer before settlement, buyer shall maintain the property in its present condition. We've got a responsibility here to inform our clients that as the buyer, the landlord, being the seller, can come in and take a look at the property. Buyer shall be responsible for utility charges applicable to the property. I'm going to go ahead and have them switch the utilities over into their name as of the date of move-in. Buyer shall be solely liable for maintenance, repair, and upkeep of the property inside and out in good and clean condition at buyer's sole expense, and shall be responsible for repairs to all fixtures and equipment, all appliances, mechanical, heating, cooling, plumbing, and electrical, and all other repairs and replacements, maintenance matters of any and every type of nature to the property, except those covered by seller's hazard insurance. We want to have a very serious conversation with if you're on the sell end of this, about them having a conversation with their homeowner's insurance. They need to know that they have to let their insurance company know before the date of the buyer moving in that they will essentially be landlords and not living there. It does change their homeowner's insurance, and it is different by each insurance company. So those conversations have to happen before, if it can happen before anything signing here, but if not, before the move-in date is determined. Other provisions, any other issues that arise, have conversations about what's important to your clients, delivery of the payment, etc., can be put in here. Insurance and liability, this covers kind of what I was alluding to before. And this is really important. We, again, need to really push them to have the conversations with their insurance company. During the period of occupancy of the property by buyers before settlement, sellers shall have the right to access the property at reasonable times for the purpose of inspection, etc. So one of the things you can put under provisions if seller/landlord does need to enter the property, If you as a buyer would like to ask them for anywhere from, a 2-hour window of notice, 24-hour window of notice, 48-hour window of notice, get it done in these provisions so it's not something that becomes an issue for anybody in the future. Buyer shall obtain appropriate insurance to protect against loss or damage to buyer's personal property. This is important. Say that there is a plumbing issue and you've got homeowners insurance involved. It's not going to cover the buyer's personal property. So they need to let their homeowners insurance know that they're moving it early and find out what they need to do to protect their belongings beforehand. It essentially looks like a situation of renter's insurance, but not having those conversations and just kind of bypassing that conversation can lead to property damage, which they're not going to be reimbursed for. Selling firm, listing firm release. This is important to point out and make sure. I like to actually sit with people while they're looking at this document so that I know that they have actually read this and we don't have to have a conversation about it later. Again, we cover our asses, excuse my language. Selling firm, listing firm, release. Buyer and seller each release and waive selling firm and listing firm, both of which shall be deemed to be third-party beneficiaries thereof, etc. What's important about this is there's a lot of times that without explanation here of this, that a buyer or seller thinks of their agent once this is signed as a property management company, and that is not what we are. We need to make that clear that any issues arising from this, shall this go awry, is really between buyer and seller. We really can't do anything to help them at that point except for paperwork. This is a binding agreement which affects your rights. And again, seek legal advice if there's any document or any part of this agreement that you don't understand. So we come down here to buyer and seller agree to the following possession agreement release terms. So once settlement has happened and that security deposit on a situation with a buyer moving in early is kind of I don't want to say questionable, but the reality is that unless things go awry, that security deposit essentially goes back to the buyer who's already moved in. And we would fill that out and have all of this filled out ahead of time to make it easy enough for, this is what the escrow company would need in order to release that deposit. Any questions at this point? All right. So I'm going to go back and jump into the seller possession agreement. I don't know about everybody else, but it's definitely been my experience that we see this used a lot more in our market, and a lot of it has to do with either people waiting to be moved for the military or people waiting for, say, the sellers are under contract on new construction. This is where we want to get ahead of this. I love it when you see in a listing, hey, sellers are going to need 1 month, 2 month, 3 month, whatever rent back. That's where we're going to get this signed in agreement, especially before ratification. This can be very difficult to negotiate once you're under contract. So we want to get ahead of this. And I do think that it falls on us as listing agents, not only to put it into the listing that they will need this, but to enter into actual conversations with the buyer's agent so that everybody is fully aware of everything that's in this agreement and its implications. So seller possession agreement date at the top, buyer seller, and then the date of the purchase agreement. And if we can have these signed on the same day, that is definitely the goal for certain property. Okay, important here, number 2, notice the possession agreement is intended to be used only when seller will remain in possession of the property for a, quote, short term after the settlement date and does not address the risks, liabilities, and obligations that are typically addressed in a periodic residential lease. In a typical residential lease, they're much longer for a reason, and they address the different liabilities. Here we are recommending, again, as the previous document, that they seek legal counsel prior to executing this possession agreement. If the client is yours on either side, have them talk to Jones, Walker, and Lake about any issues that could possibly go sideways so everybody's comfortable before signing this. Possession move-out date. Seller desires to remain in physical possession of the property after the settlement date. So we have down here what the settlement date, entitled to exclusive use and occupancy from settlement date to time, date. I do like to actually put a time in here. 12 a.m. or 12 p.m. is what I found sufficient for the date. I like that 12 p.m. if the clients know that they are leaving, say, the night before. And I'm going to come back to why, but that has to do with when the buyer is actually going to do their walkthrough. Effective on the move-out date, all sellers' rights to possession of the property shall terminate. Time being of the essence, buyer reserves the right to pursue all remedies, legal and equitable, for sellers' failure to vacate by the move-out date. Obviously, this is worst-case scenario. Can we throw together an addendum if they need more time? Sure, as long as everybody is in agreement about that. But I like to buffer this by a day or two to give them time to move out. I've seen a lot of situations, especially in the last 3 years, with moving companies that are delayed, either due to weather and such. So put in a little padding on here, and we get down to an agreement about that money being refunded. I know that I talk really fast. Sorry about that. Does anyone have any questions at this point? All right. So coming down to deposit rent, for the privilege of possession, seller agrees to provide a security deposit of, again, depending on the timing that we're looking at, I would say if it's anywhere below a month, 29 days or less, 500 can be sufficient. Again, depends on what's negotiated. If it's going to be longer than that, I would definitely go with $1,000 or more to be held by buyer at settlement. B, seller further agrees to pay buyer a daily rental rate. So there's different ways to come up with this number. Again, depending on the situation, what you're looking for your buyers. I like to take the new monthly mortgage payment, including interest, including condo fees, including anything that would be escrowed, and divide that by 30 days to come up with a daily rate. And if we are on the listing side of this document, we have to explain to our client that they're doing that based on their mortgage and not the client's mortgage. Now, if you're the listing agent and you've got, a ton of offers on this property, here's where you can negotiate that down or even completely removed. I've been able to see that happen. The buyers are so in love with this house that they're willing to forego the daily rate. I'm never going to let a buyer forego the deposit from the seller because the seller will physically be in the property, and that's closer to a typical lease agreement. But you can negotiate the daily rental rate, but we do want to make sure that we're protecting our buyers if we're going over that 30-day number. And also keep in mind that although the buyer might not have a payment on the first of the next month, they will the following month. So we do need to protect them here. To be paid in full at settlement. So both of these amounts, they're written in 2 separate checks and brought to settlement. And I have seen situations, luckily, thank goodness, haven't been involved, where the seller showed up but didn't have one or both of these checks. The buyer got excited and wanted to close anyway. And that is an absolute direct line to ending up in mediation or court. So it might not make everybody happy, but if the seller doesn't show up with a check for the deposit and with a check for the daily rental rate based on the amount of days coming up to the move out date, don't close. Postpone closing for a day, postpone closing till the afternoon. I cannot stress enough, this is one of the most important things. You have to make sure that those checks are at settlement. In the event the seller elects to terminate this possession agreement prior to the move-out date, seller's rights to the property shall terminate as of sellers vacating the property. Buyer shall be entitled to possession of the property upon seller's vacancy. This is where you can have a conversation when they've given the buyer written notice of seller's intent to vacate, and buyer may, at buyer's option, refund a portion of the rent. Again, let's have thorough in-depth conversations, what the buyer should anticipate if the seller does leave early. The right thing to do here is to go ahead and refund a portion of the rent. sufficient to the days that they left early. We don't really see that a lot. Maybe like 1 day early, and that's an easy enough check to write. In the event the seller has not vacated on the move out date, seller shall pay as rent the amount of for each day. And that's what's really important that we need to make the seller aware of, because this line here is where we can really protect our clients. So say, for example, I've written this up that the sellers are going to pay $50 a day. That's what covers the mortgage, et cetera, and escrows for the buyer. If the seller doesn't move out on that date, I will sometimes go as high as threefold, up to 150 or 200 a day. And what we're obviously looking to do here is to discourage the seller from not moving out on the due date. Again, we can protect them here. We can't really do much to enforce other than what we have them sign here, again, before we're ratified or with ratification, so that that can't be changed. And that will do our best to protect our clients if for some reason they end up in court. Unless otherwise agreed to in writing by buyer and seller, of course, we can always throw on an addendum if everybody is in agreement. Payment of the penalty rent shall be paid to buyer not later than delivery of the premises to the buyer. So say that it looks like the seller needs an additional 5 days, and the buyer has agreed to let them do that. They're going to pay the additional amount that we put up here and deliver that check on the day that the buyer takes possession. Provision for payment of the penalty rent shall not be construed as a grant for use of the property to seller beyond the move out date. They're out, they're out. That's it. They have no rights to the property. Seller shall not make any modifications or alterations to said property. Other provisions, this is where I will put in here the amount of walkthroughs we will do. I like to do a walkthrough the night before settlement, as well as a walkthrough on the actual seller move out date. And this is where I take into consideration what time I want to attach to the seller moving out. If it's going to be, say 12 midnight, obviously we're not doing a walkthrough at 12:01. We want to do it on the day that they're moving out. That can get tricky because what can we actually see if they're in the middle of loading up a U-Haul? So be very specific about when you're going to want to do that final walkthrough. Insurance and liability, again, cannot stress enough how important this is, that both buyer and seller understand the need to talk to their own insurance companies about their options here and what it looks like. The main thing we need to express is that this becomes a landlord-tenant relationship that we cannot affect, again, aside from putting together an addendum that everybody agrees on. So prior to move out date, buyer shall have the right to access the property at reasonable times for the purpose of inspection and making repairs, etc. Again, we can add to provisions a time, either a 2-hour window, 24-hour window, or even a 48-hour window, to be respectful also if there's kids and pets on the property. Let's make it fair to everybody. B, maintain in full force and effect any fire, flood, and extended coverage and liability insurance on the property as of the settlement date. Buyer shall not be liable to seller, not for seller, but to seller, for any loss or damage to any personal property. So again, when the buyer has a conversation with their insurance company, they're going to be explaining that, hey, they're actually going to be legally tenants until such and such date, because that changes their insurance and what's covered. And we want to make sure everybody's personal property is covered. Property, and I want to come down here. Buyer and seller shall, seller shall hold property harmless from and against any damage to any of seller's personal property, any type of nature arising from seller's possession of the property. Buyer shall not be liable to seller for any bodily injury or property damage suffered by seller or seller's guests or family members. Again, more reason why we need to stress they need to have a conversation with their insurance company. And the important part is that we're getting everybody to sign. Everybody's in agreement, at least on the date of signing. Move out condition use of deposit. Seller shall remove all of seller's personal property and deliver the property to the buyer on the move out date in broom clean condition. Because that's what it states here, I actually like to come back up to provisions, discuss with my client what they're looking for. If they are really more interested in a deep clean, We need to actually state that. Otherwise, it is not a given. If we want to put in here cleaned and sanitized, if we want to put in here professional and provide invoice. So that's a tendency of what I happen to say is a professional clean with an invoice provided. That's one way that we can cover them. Seller shall comply with any rules or regulations of homeowners or condominium association applicable to property. That is an easy one to understand. Seller shall be responsible for the repair of any damage to the property above normal wear and tear, which occurs during seller's occupancy or as a result of seller moving out of the property. This is for, dings, holes, things in the wall that weren't there beforehand. This is why it is really important not to forego that walkthrough the night before settlement, even though the seller is staying in place. For the buyer's walkthrough, get in there not only to make sure that everything works the day that it did the home inspection, but go ahead, take a look at the walls, take a look at the staircase, take pictures, just to make sure that nothing gets damaged on move out. I have also seen here where buyer comes in after the seller moves out and pulls up rugs and then finds that there's actually issues with flooring or carpet. So as the buyer's agent, that's something that we need to do. I recommend doing when you do the first walkthrough to compare to the second walkthrough, because those are things that are easy to miss and honestly easy to cover. So buyer reserves the right, we're back up right here. Buyer reserves the right to have a move out inspection on the move out date to determine seller's compliance with this paragraph and to confirm the presence of personal property previously conveyed. Buyer may use the deposit or portion for the repair of the items in the preceding sentence not repaired by seller. Most situations where everybody's trying to do the right thing, seller will say, oh, you know what, I messed up a railing or I messed up a wall. We can either get it fixed or take that out of the security deposit. And then we're going to use the attached move out inspection report, as well as the release. And then we have our timelines here. We definitely want to have conversations about these before we have anything signed, so everybody is completely aware of what is expected of them. So starting with seller's possession agreement, release to seller within 3 days. This is talking about the deposit after the move out date or such earlier date, because they can move out earlier, obviously, as may be set forth in written notice from seller if seller elects to terminate this possession agreement. Utilities, maintenance, and repair. All parties agree. Obviously, buyer or seller shall be responsible for all utility expenses incurred in connection with the use of the property from settlement date on move out date. To keep from having to go back and forth with utility companies, it's a great idea for the seller. If I have the buyer in this situation, I'm going to ask that the seller keep the utilities in their name until their actual move out date, and a week beforehand have the buyer call and put the utilities in their name. The only time that we can't do this is obviously if we're dealing with utilities that are through a condo association, say water and things like that. But you do want to let the condo association know. Where are we? Other than that, as specifically set forth in this paragraph, buyer shall have the maintenance and repair responsibilities for the property, including all appliance, heating and cooling, plumbing and electrical. So again, the buyer is upon settlement with the seller staying, buyer legally becomes the landlord. And these are all things that a traditional lease would say as far as what the landlord is responsible for. So this covers them here. And all other equipment from and after the settlement date, except damage caused by seller's negligence. Worst case scenario, we have somebody who stopped up a toilet, who tried to wash something too big, messed up the washer dryer. And we don't want to obviously see these things happen, but determining seller's negligence can be really difficult. In this type of a situation, this is where we do sometimes need to bring in an attorney. Intentional conduct or otherwise described in this paragraph, seller shall promptly notify buyer of any repairs or maintenance required to make the property made to the property, and buyer shall promptly make such repairs. So as the buyer is now the landlord and there is a leak, or something that would fall under the umbrella of what the buyer would be responsible, buyer slash landlord be responsible for fixing, it needs to be done in a reasonable time. You can't say, well, we'll do that when you move out, because you are the landlord and you are still responsible for providing a habitable property. And this is where we need the seller to inform the buyer ASAP if there's any issues. Buyer bears the risk of condemnation and casualty from and after settlement date, except any risk of loss to seller's personal property, again, because their personal property will now be covered under their tenant insurance. Governing law, entire agreement. This seller's possession agreement survives the settlement and shall be governed by and construed in accordance with the laws of the Commonwealth of Virginia. And that's where you would look up landlord-tenant laws. Constitutes the sole agreement of the buyer and seller with respect to the seller's possession of the property after settlement, and may only be modified or amended by an agreement in writing executed by buyer and seller. So although they have a tendency to think of us as property managers, we are not. But the one way that we can stay involved is if they have an understanding or an agreement that changes anything in this possession and both sides agree, let's go ahead and throw that on an addendum for them to be signed by all parties. And those will be addendums that you as the agent don't sign, just between buyer and seller. Selling firm, listing firm release. Again, this is what covers our ass. Buyer and seller each release and waive selling firm and listing firm, both of which shall be deemed to be third-party beneficiaries hereof from all claims, demands, actions, causes of action, and counterclaims of any kind or nature, whether known or unknown, whether each buyer and or seller individually and or collectively now have, etc. Any issues arising doesn't fall on the agents, and talk to an attorney. Filling this in is important. Seller new address is what needs to be here. And you absolutely want your seller to fill in their phone number here, because even if things are going swimmingly, the buyer and the seller as of settlement date will have each other's information. And that, again, prevents anybody from believing that we are property management, because we're not. And then coming to the actual final walkthrough, seller's possession move out inspection report. And this is where we would fill out if any repairs are necessary, if any personal property previously conveyed is missing. So say, for example, there was a hot tub that was negotiated and then they do stay to convey with the property for the buyers, and then it is gone. Say the sellers decided to sell it or what have you. That can become an absolutely enormous issue. Following items require repair in accordance with paragraph, etc. And or the personal property items are missing. This is where we would fill in that. And if there are no issues to be repaired, we're going to come down to the seller's possession agreement release pursuant to paragraph 7 of possession agreement. Buyer may use deposit or portion thereof. So say, for example, there was an agreement for a professional cleaning to be done and they didn't do it. You can provide a quote on an invoice as the buyer for how much it would be to have the property professionally cleaned as previously agreed upon, and show that to be taken from the security deposit. That's the one example that I see used the most. And again, where we can protect our clients by making sure that we have added that to the provisions section. Because otherwise, honestly, broom swept, I firmly believe, is an opinion. It is not a state of fact of how a property should be left. And then we have buyer and seller here. And if you will notice, the important thing here is there is not a place on this document for either agent to sign. Again, we can be involved in any kind of addendum agreement as long as all parties agree. But we are not in charge of or responsible for anything, especially having to do with the deposit, which is why we as agents and we as a firm don't hold these deposits. But very important there. I know that that was a lot in a brief period of time. Does anybody have questions? I see that Lucy is on here, not to call you out, but I wanted to know if you had anything that you wanted to add to this. Does anybody have any questions? What do we have? Lucy says, as a listing agent, don't take a buyer possession. I could not agree more. It's just incredibly risky because financing, number one reason financing can fall apart, and all of a sudden you have somebody in a home with just the bare minimum of paperwork, and getting them out, you would honestly have to literally evict them. So I definitely agree with that one. That's important. And honestly, if you've never done a seller possession or a buyer possession, before having anybody sign, before even sitting down and going over this paperwork with your client, talk to a mentor, talk to the broker, talk to Lucy. Let's get the verbiage right, because this is in the beginning where we can kind of only and best serve our clients to make sure that they are protected. So if that is it, that's all I have on these. Those were the only two that I hadn't gone over yet this year. Hey, Charlene, thanks for joining. And I'm going to go ahead and sign off unless anybody has anything else. Thanks for coming, guys.